Ebe ọma na-ege ntị, anyị ekene unu ọzọ n'ụbọchị uhuruchi tata. Anyị sịkwa unu nke onye chikwara ya zelu, unu ya dịka echi. Echi adaghị agwụ agwụ. Otu anyị kwuru otu a ka ọ ya dịrịrị. Ise ise ise. Dịka o si dị, o nwere ife anyị wetara unu dị oke mkpa n'ilu akwụkwọ. Mana nkwa anyị kwere unu n'ilu akwụkwọ bụ na anyị ga na-adrọpụrụ unu update ọbụla bụ gbasara maka ihe na-eme n'ala Igbo and ka Igbo ga-esi dị na mma. Ọ nkwa ikwere unu anyị ga na-eme. Ịghọtago? So I will tell you nnukwu update from the special counsel to Maazị Nnamdi Kanu bụ ALOY Ejumakọ. Achọkwunu ga ya bụ ife ya nnukwu victory concerning ihe a na-eme concerning nwere onwe nke ndị Igbo na-azọ. Anyị ga-esi ya bụ ife, drop right comment gị on the comment section below. All right, over to you, the barrister. Over to you, sir.
That scored this landmark victory at the Enugu State High Court today on behalf of Maazị Nnamdi Kanu. The subject of this lawsuit is simply the proscription of IPOB in 2017. Firstly, by the Southeast governors who fired the first salvo on 14 September 2017, followed by the executive decision of the federal government to proscribe IPOB and declare it a terrorist organization. We didn't come to court to contest the judicial proscription. It's a different matter altogether. But the executive decision or executive action taken before the judicial decision. Why? Because such actions are prohibited expressly under Section 42 of the Nigerian Constitution. It's a fundamental right of every Nigerian citizen not to be discriminated against in the exercise of government policies, actions, and decisions. It's clear under Section 42 of the Constitution. A lot of Nigerians are not aware of this, so they let it fly each time the government steps on them through its executive actions or decisions. But we are vigilant to that. So we noted that the action that the Southeast governors took, proscribing IPOB, was an executive action. It was an executive decision, followed 3 days later by the federal government that raised a memo through the Attorney General of the Federation to the President approving the proscription of IPOB and declaration of the group as a terrorist group. All of this together combined constitute the prohibited executive actions or decisions they sought that Section 42 of the Constitution prohibited. It's a fundamental right, meaning you cannot violate it and get away with it. It's a right that is inherent in every Nigerian, in all of us. So our case in chief is that there are other ethnic-tinged organizations across Nigeria that pursue one group interest or the other, political, mostly, or commercial. I'm not here to name names. Nigerians know that there is a proliferation of ethnic-tinged organizations. Some of them are even very evidently violent. But the federal government never took any step at all to either proscribe any one of them or to declare any one of them a terrorist group. But it took this proactive step, supported by Southeast governors, in targeting IPOB particularly, because IPOB caters to the interests of the Igbo man and their cousins from the south side of Nigeria. There is no way of denying this. You can make all these allegations in the media and in beer parlors and everywhere, but if you don't take them to court to be adjudicated, they will remain mere allegations. So we decided that the next best thing to do, that instead of debating this in the public, let us test the authenticity or the wrongness or rightness of these actions taken against IPOB in court, and we did, and we prevailed today, to the glory of God.
So what
Thank you.
Said the take home from this judgment, not only the fact that 6 years after, you want to take that instead.
Yes.
To test the potential.
Well, okay, it's to the glory of Nigerian law that pursuing fundamental rights doesn't have or does not admit of statute or limitations. You can pursue your fundamental rights anytime that you wake up to those rights. So it cannot be defeated by a fluxion of time. So there is time for everything. Even in the Bible, it is said that there is time for everything. Because of the escalation of the persecution that is being tagged as prosecution of IPOB members, mostly Igbo youths and some from the South, by the departed government, the previous government, and because maybe the present government has not come to terms with that, we decided that every right broken must be pursued in court. Every wrong done must be pursued in court.
Finally, out of the 7 days, 1 to 3 were granted, they even want to be awarded. So what would you say you wanted out to for the court for it to mediate the appeal at the Supreme Court, which this court said it doesn't have jurisdiction?
Yes, of course, we are lawyers, so we are going to go for the whole hog. So we asked for a whole lot of reliefs, including stopping the prosecution of Nnamdi Kanu, and it's grantable, but the court declared that it doesn't have jurisdiction to do so. But it proceeded to graciously grant the reliefs that in its wisdom, it felt it has jurisdiction to do so. Number one, it declared as unconstitutional and as a violation of the fundamental rights of Nnamdi Kanu that action of proscription was taking, proscription and declaration of IPOB as a terrorist group violated Section 42 of the Constitution. That's a big win. And then secondly, the judge upheld our argument that self-determination is not a crime and therefore cannot ground.
Boma na-ege ntị darụkwanụ rinne nụ. Anyị sịkwa nọ ya duru na mma. Anyị unu ga-adị ka echi na echi ada agwụ agwụ. Anyị dịkwunu si esoela anyị. Anyị sị na Chukwuka abịa ma ga-anọ elu niile n'ofu n'ofu. Nna anụgo ka o si gbata wee kwụrụ. Ya bụ ụmụnne anyị nke kpọrọ anyị na anyị bụ terrorist. Tata na unu fụ na Chukwuka abịa menyego ndị IPOB mmeri. Maka na Eastern Governors niile gbakọtara aka ọnụ wee kpọọ all the whole IPOB a terrorist organization, proscribe offer it as a terrorist. And n'ụbọchị nke taa na Chukwu enyego ụmụ Chineke mmeri. And unu ka o si wee gbata wee kwụrụ n'ọnụ Special Counsel of Maazị Nnamdi Kanu, ALOY Ejumakor, nke wetara ọtụtụ ntụrụugo a n'Enugu steeti, Federal Court Enugu State, wee nye na Maazị Nnamdi Kanu 8 billion naira for damages for a terrorist and so many other things. The court declared IPOB prescription illegal, awarded 8 billion naira damages to Maazị Nnamdi Kanu. So unu afụgoni ka o si wee dị, nke dị ka ibe ya bụ ka efu unu nwere ike ikwu n'ụdị nke unu gbasịta maka ife mmeri a ewetelu and nnukwu mmeri abịanụ na IPOB and also the indigenous people of Biafra and also to ndị Igbo ka unu nwere ike ikwu gbasịta maka ya bụ mmeri, nnukwu mmeri anụwa. Dropụrụ na ya on the Eastern News 24. Ife a bụkwa ebe anyị si na-ewetara nnukwu ozi ya dị oke mkpa. Gbakwanụ mbọ ka isi ya ka o litekwana ụmụnne anyị ndị ọzọ n'ebe tere aka ka fa wee sorokwa ya wee gee ya bụ ife the update nke na-eme n'ala Igbo. Ngwa daalụ nne nụ ụmụ ife ka emesịanụ. Also stay tuned at Eastern News 24 ebe anyị si na-ewetara nnukwu ozi ya dị oke mkpa. Daalụ ụmụnne m ka emesịanụ.